Good morning and welcome to this webinar, which will help you complete an outcome in cases where the statutory charge attaches or where your client's been awarded costs. My name is Gareth Partington and I've been with the agency for more years than I care to remember. I've been on the civil finance team in the Liverpool office for the past 9 years. So the first thing we'll be covering is what is an outcome, which is slide number 6 in the presentation pack. Put simply, an outcome is your way of telling us that the case is concluded, and once you've informed us of this, we can discharge the certificate and you can submit your final bill. To ensure that the outcome is processed as quickly as possible and to prevent any issues when the bill is processed, it's important that the date you give for the date of final work is the date on which the matter concluded, and this will generally be when you've done the last substantive work on the file for your client. Another important thing to note is that unless the certificate has already been discharged or revoked, please provide a reason for discharge of the certificate. If you don't do this, the outcome has to be cleared and rejected back to you, as caseworkers in the agency don't have access to your side of CCMS, so aren't able to add that information themselves. Once the outcome has been submitted, it allows the agency to record the decision as to whether or not the statutory charge attaches and to record the position if your client's been awarded costs.
Good morning. I'm Linda Wall, Senior Caseworker in the Liverpool office, and I've got many years' experience of dealing with billing and outcomes issues, including complex statutory charge and cost cases. Turning to slide 7, where to submit an outcome. So in most cases, everything happens very smoothly, but there's a few cases where it might not be quite so obvious. So we thought it would be helpful to just spend a couple of minutes on this. So where there's multiple proceedings on a case, we just want you to submit one outcome once all the proceedings have concluded. Generally, suppliers will send us an outcome at the point where they want the certificate discharging, but that may not always be the optimum time. So sending it to us early is generally going to be good practice, and particularly from a statutory charge perspective, if the statutory charge may apply on the case. Also, once the certificate's discharged, at that point your client can stop paying any contributions. And also, once the certificate's been discharged, it reduces the risk of delays in processing your final bill. If we don't receive your claim within a certain time period following the discharge, we can send you prompts. On cases that involve the statutory charge or costs, there may be additional factors to consider, and we look at these on slide 8. So where there's a possibility of the charge arising, you're under a duty to report to us promptly once the terms of the order or the agreement are known. If you don't wish the certificate to be discharged at that time, we'd still ask that you report to us, preferably by way of an outcome rather than a billing inquiry. On cost cases, it's a little bit different. The final outcome with the completed cost award can only be sent to us once cost negotiations are concluded and any payments been received, or in matters where cost recovery hasn't been successful, where there's no further recovery work to be carried out under the certificate, and in the event that discharge is required at an earlier date, that can be requested by way of a case inquiry.
So we're now on to slide 9 of the presentation pack. And what do you need to upload with an outcome? The final order that's been made in the proceedings always needs to be uploaded. If no final order was made, you'll need to upload the closing letter you sent to your client, which confirms how the matter ended. In a family case where monies were sought or a property was an issue, it will save time in the long run if you complete and upload a Civ Admin 1, which we'll call an Admin 1 from now on, just to save time. We'll be going through what's needed on the Admin 1 in a bit more detail later on in the webinar. It's important to note that the uploaded form doesn't have to be a copy that's been signed and dated by your client. In the Admin 1, tell us what each party's position at the start of the proceedings was, as well as details of any offers and counter-offers that were made. The parties' Form Es may be useful, so it's worthwhile uploading these as well, especially Section 5, the order sought questions.
One thing that sometimes causes hiccups is legal help reporting, and that's particularly important in cases where the statutory charge will arise. The information that's entered there in the pre-certificate and legal help cost screen will be used to calculate any statutory charge liability. The statutory charge is calculated by reference to the cost of the funded services. And in cases where a certificate has been issued, that will include costs claimed under the certificate and any costs claimed under controlled work. When you're entering legal help on CCMS, please check carefully when completing the outcomes and make sure that the figure entered reflects what you've received, including any VAT or disbursements. And if you've opened a legal help file, but you're not going to be making a claim under legal help, then it would be great if you could let us know under the other information box, and that would avoid us needing to send a possible further inquiry at some stage.
We're now moving on to slide 12 of the slide, and we're giving you a bit of a background on the statutory charge. And as you can see from that slide, the statutory charge is designed to put legally aided clients in the same position as non-legally aided clients, where the opponent hasn't been ordered to or cannot pay your client's costs. It will therefore give your client a financial interest in the proceedings and can act as a deterrent to them running up costs unnecessarily. Chapter 2 of the Statutory Charge Manual gives a fuller picture of the statutory charge, and a link to this manual is given at the end of the slides. Slide 13 sets out the statutory provisions for the statutory charge in legal aid cases, and this is Section 25, Legal Aid, Sentencing and Punishment of Offenders Act 2012. And as you can see from that slide, the section's been set out for you in full, so I'm not intending to say any more on that now. Slide 14, as you can read, gives an explanation of what the agency regards as a recovery. In a family case, if a jointly held property is transferred to your client's sole name, or he or she is granted a bigger share of the property than they currently hold, that's a recovery. In non-family cases, any award of damages is regarded as a recovery as well. Slide 15 sets out what the agency classes as preservation, and this is where your client fends off a claim to his or her property or their possession of it. Preservation will also occur if the opponent was seeking a sale of the property, but your client was successful in defeating that and avoiding an order for sale and remained in the property. Before we move on to the technical side of completing an outcome where the statutory charge attaches, we'll go over the completion of an Admin 1. As I said at the beginning of the webinar, it's important to remember that you don't have to send us a copy of the form that's been signed by your client. Slide 17 gives you a link to where the form can be downloaded from. We'll be going over an example with dummy information for the next few minutes. It's been provided with a slide so you can look at it as I go over it. So we're now going to go through the Civ Admin 1 and give you some guidance on how it's to be completed. It's important to remember that you don't have to send us a copy of the form that's been signed by your client. Page 1 of the form is simply a case of completing your client's name and legal aid certificate number and your firm's details. and it's self-explanatory, so I'm not going to dwell too much on this page. Page 2 is perhaps the most important page of the form. If extra space is needed, please add the additional pages to the form and let us know that you have completed extra sheets. The first question is where you set out what each party's opening position was. If the opponent didn't engage in any way, so proceedings had to be issued by your client, please let us know that here. This section of the form is also where you can set out if any offers or counter offers were made and what the details of those were. The second section of page 2 is where you can let us know what the final order provided. Although you can refer us to the order, it makes processing the outcome easier for the agency's caseworkers if you can set out here what the provisions of the final order were. And the next section is where you provide information about the value of the property. As with the section above this, it makes the outcome quicker to process if you provide us with a title number where indicated. Page 3 of the admin one is where the acting solicitor signs and dates the form at the top of the page, and if you're making a bank transfer, you can to satisfy your client's liability under the statutory charge, you can let us know here and complete the undertaking that the total claim on the fund won't exceed the amount you're sending us. You'll notice that the form still refers to you sending us a check, but this can be ignored. Feel free to edit to state that you're making a bank transfer if you wish. If the property is to be used by your client as a home for themselves and or the party's children, and they're seeking to postpone the statutory charge, please let the agency know this by ticking the second last box. Pages 4 to 12 of the form are completed where postponement of the statutory charge is being requested. Page 4 sets out information about the property and whether you'll be applying for the agency's charge yourselves. If there's to be a conveyance, but your firm isn't dealing with that, you can let us know the details of the firm that is on this page. Page 5 is where you give us details of your client's financial situation and whether or not they've been able to obtain some form of loan so as to satisfy the liability under the statutory charge. You can see that pages 6, 7, 8 and 9 provide information about the agency's privacy notice. So I won't be covering these pages right now because they're all sort of self-explanatory. Page 10 is where your client signs and dates the form. And page 11 and 12 are completed where your client is using monies to purchase a new property. Page 11 is where information is provided to us about the property itself, so its address, title number, etc., and who the proprietors of it are to be. And page 12 is the page which your client plus any proprietors sign the form and where their witnesses sign. It makes it very much quicker for us if the declaration on page 11 can be dated by your client. And that covers completion of the admin 1 form. So we'll now return to the slides for some more information on completion of the information on the outcome itself. Slides 18 and 19 are the next slides we'll be looking at, and as you can see, it tells you what sections need to be completed where your clients received various types of settlements, and there are screenshots from that is the supplier side of CCMS. If your client received a lump sum in a family case, please complete the damages element. If there's been any sort of adjustment in how the property is held between the parties, or there's an order for the sale of the property, it's the land element that you have to complete. And if there's any other assets involved, for example, a car or antiques or jewellery, then the element to complete is other assets. Please complete these sections with as much information as you can. Remember that you can use the other information sections to provide anything else that you think may assist us to process the outcome. Slide 20 sets out some tips that will help us to process the outcome first time, and will help you to get it resolved more quickly. So if there's to be a sale or transfer of the property in the future, tell us what you know about the progress of that sale or transfer, and tell us the name of the solicitors dealing with the conveyancing if it's not yourselves. When drafting the final order, remember to include the statutory charge postponement clause, because that can save an awful lot of time in the future. Also include your client's proposal to satisfy the liability under the statutory charge, and transfer the monies to satisfy your client's liability by way of a bank transfer. The information you'll need to do this is set out on the slides there, and it gives the bank the account name, the sort code, the account number, and the payment reference, which will always be your client's certificate number. If you have sent us a payment already, please confirm the amount and the date it was paid, so this can be matched up with your client's account.
The next group of slides deal with cases where costs are involved. So if costs have been awarded to your client, the first thing we're going to need is a copy of any order for costs and raising a costs award on CCMS. Please complete the screens as fully as you can, and if you're unfamiliar with the process, there is a quick guide on cost awards that you may find helpful. And if you still have questions, drop us a billing inquiry, and there's a fair chance that I'll be the one who picks it up. So what we need is copies of all orders for costs and to raise a cost award on CCMS. Make sure that you click calculate at the bottom of the page, and that will give you the total recovered and total unrecovered figures. In cases where costs have been recovered in full, you've got the right to retain the recovered costs and to restrict any claim against the fund to costs that weren't recoverable from the other side. And in the vast majority of cases, that's exactly what we see happening. If damages are also recovered, please submit a payment to cover the statutory charge, or indicate in some way if there's no claim to be made against the fund. The agency won't be able to give authority for the release of any monies unless we receive a written undertaking as to costs. That's in cases, obviously, where we've not yet received a final bill. Finally, on this slide, if you use the text field to indicate whether you've recovered any legal help costs or interest on costs, which should be recouped by the legal aid agency, because that's something that, unless you put something there, we're likely to raise a query on it. Slide 24 deals with calculation of interest. I'm not going to go through the calculations that you can see on the slide. You can go through these yourselves in your own time. And I think that the main thing to emphasize is that the key to the calculation is first working out how much inter partes costs have been recovered at legal aid rates, as the legal aid agency will be due a portion of the total interest recovered on a pro rata basis. For further guidance on the calculation of interest, including an example, please refer to section 19.4 of the Civil Finance Electronic Handbook. So, slide 25, where costs can't be agreed, you have the option to apply to amend the certificate to cover enforcement. But let's say that you've arrived at the point where there's no more that you can do and you just need to get the certificate discharged. The key things to bear in mind are that you'll be claiming all inter partes costs from us at legal aid rates, and the agency will be responsible for recovery of the outstanding costs. So, very important that all the information provided on the outcome of the cost award as complete and accurate. And what we will need will include the order for costs, the default cost certificate, and any relevant correspondence that may assist in enforcement, including any correspondence, obviously, with the other side. So turning to how to complete the actual cost award in these cases. Slide 26 goes through it step by step. So the LAA rate figure, that will be the amount of inter-parties costs that's being claimed from the LAA, which will sometimes be shown on a separate schedule that's attached to the bill of costs. The market rates figure will be the total of the default cost certificate inclusive of court fees, minus any pre-certificate costs that aren't being claimed from the LAA, and minus the LAA rate figure. So the total that's payable by the defendant can be calculated by adding up the LAA rate figure, the market rate figure, and if there's any pre-certificate costs involved, then the pre-certificate costs as well. And that should all come to the same thing as the total of the default cost certificate. Then just finally in this section, that the date and address of service needs to be entered, and the other party's name and address must be entered in the liable parties section, and that information will all go to our recovery services team. Slide 28, cost award reporting after final bill payment. So this is something that can arise if recovery is made under a linked certificate, under a conditional fee agreement, for instance, in inquests or other cases against public bodies, or where the cost award wasn't reported for whatever reason on the original outcomes. So first thing is, we still need you to report the recovery to us where certificated costs are impacted, even if the recovery was made under the CFA. That will involve a fresh outcome being submitted with details of the cost award and any recovery made. At that stage, we'll initiate any recoupments of already paid certificated costs that were recovered as part of the settlement. So we're not asking you to send us in any checks or bank transfers for monies that you want recouping, because we will deal with all of that ourselves. The slide 29 is the step by step of the process to be followed. So assuming that this is the case that's already been closed on CCMS, what you need to do is submit a general inquiry via the CCMS portal, indicating the certificate number, advising that a recovery of costs has been made and asking us to reopen the matter. The inquiry should also detail all the amounts to be recouped, and remember to include not just your costs, but any counsel fees, interest on costs, and legal help. The agency will clear the previously submitted outcome, enabling you to submit a fresh outcome to upload the order for costs. We'll then process the outcome and any recoupments once the new outcome has been submitted.